Hi, I'm John Leonard. I'm a corporate lawyer in Denver, Colorado with Fairfield and Woods. We have a set of videos on our website, talks about various issues of the law and how it interacts with our business clients. And we have a set on estate planning as well. We have a great set of Colin Walker does on employment law as well. So a lot of videos on our website. Today, we're actually talking to one of our litigation partners, Paul Yonda. Paul's a litigator and has done 3 videos we just did on how to start a lawsuit, what to do if you're a defendant, the discovery process, and what happens at court. This one is kind of in the middle, how things settle midway in a lawsuit, how many cases settle and how you settle them. But anyway, thanks for joining us today talking about litigation. I guess a lot of cases don't go to trial, they settle either through mediation or some sort of settlement agreement. What is a settlement? And how do you get a settlement in a lawsuit that's been started? And who blinks first? Who mentions the settlement first, I guess?
Sure. So this is a topic that I'm excited to talk about because I think this is the bit that often our clients don't quite understand coming into it. You know, we represent some big entities here that get sued frequently and know the process really well. And we also represent small businesses, individuals, and families who are less accustomed to this process. And so sort of the settlement and mediation are where we get hung up because it's not what people are expecting. And as I mentioned earlier, courts generally order that you participate in alternative dispute resolution, which is typically mediation. And that's just that's a negotiation process between the two parties with the mediator going between them. It isn't the mediator's job to decide any facts. They're just sort of assisting the parties in that negotiation because if there was a lawsuit and you're good ways through it, obviously people have a lot of disagreements and it might be kind of difficult to talk. So the mediator is typically a retired judge or a long practicing attorney who can help the parties sort of reach an agreement. And the nice thing about a settlement agreement is it can include all sorts of things that you wouldn't get at the end of a trial. At the end of a trial, you're going to get a verdict from the judge and that says one side has to pay the other, often in the types of cases we handle. And that's it. There are no other terms. There aren't a lot of other things that the judge can do. And that's all public. And that may not be what you want. As part of a settlement agreement, if you're on the defense side and you're maybe going to be paying the other side, you can get payment terms. You can get confidentiality associated with that agreement. So no one ever knows what was paid. And you can get a term that you're not admitting any fault. Whereas if you get to the end of a jury trial, someone is going to be said to be right or wrong, and it'll be in the public record forever. But the big reason parties settle, and it's a hard thing because we're talking ourselves out of work as litigators, is that trials are very, very expensive. And juries are extremely unpredictable. We talked earlier about a summons. You and I probably get jury summons from time to time. And your jury is just 6 random people deciding these issues. And for many of our clients with complicated business issues, just whatever 6 people ended up in that box may not be best equipped to determine the resolution. So you don't know what's going to happen. There's a great deal of unpredictability and risk. It's very expensive to go to trial. And you settle it and you can get whatever you want as a term of that agreement.
So let's back up. Somebody starts a lawsuit, there's an answer. Is the mediation fairly soon in that process, or do you wait until you'll have to watch this video? The discovery process goes on for a while, but when is mediation done? Near the beginning or near the end of the process?
Mediation can happen anytime. It can happen before the lawsuit. It can happen after the jury verdict. Most typically what happens is we're mediating cases after discovery. So we've sort of exchanged our facts. Essentially, all the cards are on the table. And so that allows the parties to really get close to that resolution.
And I thought that was great that the mediation, there isn't a decision there, but the parties arrive at a settlement, and then there's another deal. There's a negotiation of what that settlement's going to be. Payment terms you mentioned, no admission of fault, perhaps, those types of things. So there's actually kind of another agreement and a release of claims, I guess. What's in a settlement agreement?
Settlement agreements can be as short as the pages you and I are looking at to being very long and complicated. In a commercial relationship, for example, you might be renegotiating important terms of an LLC operating agreement as part of the settlement. So tons of paperwork associated with that. It can also be as simple as party A is going to pay party B X dollars in exchange for a release of all claims, and that's it. And you know, we can fit that all in a couple of paragraphs.
And so if you wanted to save a relationship that obviously went off the skids because a lawsuit was filed, you could redo that relationship, mediation, and then a settlement agreement. You mentioned you could redo provisions of an operating agreement for a company. You could do all sorts of things to maybe save that relationship between mediation and a settlement.
Right. And for business clients, that is really one of the big advantages, because by the time everyone's gotten to a jury verdict, it's probably going to be hard to go forward with that relationship after the difficulty of that entire process. Whereas you get a little ways into the lawsuit, you negotiate some terms, and everyone can maybe move forward together if that's a relationship you're intent on preserving, or at least avoid some of the risks that would come along with just leaving the decision to 6 random of your
Right.
citizens.
Well, great. We're going to talk about arbitration next, but Paul's done a series on litigation, how to start it, the discovery process, the trial. We just talked about settlement and mediation. We're going to wrap up with 1 or 2 videos on arbitration. Thanks for joining us.